Hello everyone, my name is Brent Ostrum. I am a senior forensic document examiner with the Canada Border Services Agency in Ottawa, Canada. For those who do not know me, I've been a document examiner for roughly 37 years, first with the Royal Canadian Mounted Police and now with CBSA. Over the years, I've been involved in various activities, including standards development with SWIGDOC, OSAC, and other groups. Our section, for reference, is also a member of the European Network of Forensic Science Institutes, with both NFEX and EDWIG. My talk today is about reporting and also testimony, both critical aspects of our work. To guide the discussion, I'll be referencing a review done a few years ago that looked into forensic handwriting examination and human factors. I was personally involved in that project. However, my comments today are solely my own, do not represent any group or organization involved in that project, and nor are they necessarily the views of any of the other authors. The report I'm talking about is entitled The Forensic Handwriting Examination and Human Factors, Improving the Practice Through a Systems Approach. Now, a working group was convened in 2015 with a final report, 250 pages long, published in 2020, updated in 2021. Now, the initiative was supported jointly by NIST, the National Institute of Standards and Technology, and the NIJ, National Institute of Justice in the United States. The mandate of the working group was to perform a comprehensive scientific review of the status quo in forensic handwriting examination and to produce recommendations for the future, all with a human factors perspective. Why would I want to use this report to guide my comments today? Well, it's a very comprehensive review of our work, addressing many human factors issues and concerns, and it provides valuable conclusions and recommendations. It is, however, not a well-known report, which I think is a shame. I do acknowledge that the review done was U.S. or at least North American centric. However, the recommendations are for the most part applicable to any jurisdiction or legal system. There's no reason whatsoever to believe that basic human factors issues will differ significantly in different geographic locations. Now, human factors is the scientific discipline concerned with understanding interactions among human beings and other elements of a system. And it's also the profession that applies theory, principles, data, and other methods to optimize human well-being and overall system performance. Now, in our case, this generally means ways to avoid or minimize error. Human factors that contribute to error can range from inadequate training, exposure to extraneous or irrelevant information, poor judgment or decision-making, or even limitations in human vision or sources of stress. More broadly, systemic issues, which often are seen as management policies or practices, might include insufficient resources or substandard working conditions, all of which can prove detrimental to the work. The idea was to analyze human factors relating to forensic handwriting examination to see what issues exist, how they arise, and how they might be prevented or mitigated. Then use all of that to inform the development of strategies to reduce the likelihood or impact of errors. My talk today is only going to focus on Chapter 3, Reporting and Testimony. Communication is an area where human factors are extremely important, and the forensic report generally serves as the primary means of communication between the scientist and other parties in the criminal or civil justice communities. Now, the working group's review process was extensive and covered a lot of topics, and they've been laid out in these 6 chapters. Most of the topics covered in the other chapters come together in Chapter 3, simply because reporting and testimony touches on all elements of our work. Now, any discussion of these other chapters would take a long time, which we simply don't have, so I strongly recommend reading the full report for yourselves. The report touches on a lot of areas and makes many recommendations. Now, the process was not about simply creating rules to be followed. It was about doing the right thing for the right reason, to ensure, as much as possible, proper, complete, and accurate understanding of our opinions in a given case. Of course, these are ultimately just recommendations. An examiner or a lab may choose to adopt these recommendations or ignore them. However, there are good reasons behind all of the recommendations, so ignoring them is a debatable strategy unless you have good reason to do so. In any event, my talk today focuses on Chapter 3, Reporting and Testimony. So let's get to it. Chapter 3 was the one I helped to author, along with several other individuals. Our focus from the beginning was on communication as a process involving a creator or sender of the information, that'd be the examiner, the medium, the format or means by which it's communicated, and the various recipients of the information, and how that information might ultimately be interpreted and used. We considered things like the tools and procedures that an examiner might employ when writing a report, their choice of words or report structure, including the logical flow of the report. We also looked at how a report might be most effectively communicated to the courts, whether it be as a written document on its own or through testimony. Chapter 3 covers a lot of important issues, and each of the sections shown on the slide include a lot of background detail and reasoning. They also include a number of recommendations, which I plan to touch on to give you some of the rationale behind them, at least from my perspective. The first 3 sections in the chapter set the context and the approach for the rest of it. So I'm going to briefly summarize the key points in these areas before getting into the resulting recommendations. Section 3.1 looks at the value of a report. Now, it's fairly obvious, but a report's a record of the parameters, methods, examinations, limitations, and conclusions that are found regarding evidence. It's noted in this section that information can be in either or both of the report and the case file. Ideally, it should be in the report, but if not, then in the case record. Remember that in many instances, the issues are resolved through pre-trial plea bargaining, where only a report's provided. There never is a trial or testimony, and even in some trials, the report will be entered as a standalone document without testimony. Hence, the information in the report, and not the case file, is of paramount importance. The next section, 3.2, notes that human factors affect everything relating to human communication. To have meaning and to be understood, a lab report must be comprehensible and have a logical flow. The challenge is to write a report that mitigates cognitive human factors by writing a clear, unambiguous report based on established scientific examination methodology that's logically sound and sensible. Now, of course, the recipient of a report matters a great deal. Every reader has a point of view and their own inherent biases that will or may influence what they take out of a report. Each reader will have their own pre-existing personal biases, and we're limited in what we can do about that. But a well-written report that minimizes ambiguity will go a long way towards good and effective communication. Many people, lay people, also believe that more experience equals better performance, which of course is not true. Research has shown that accuracy is not related to years of experience. People also tend, in general, to prefer certainty over ambiguity. It's very problematic for forensic science, which is always uncertain, contrary to what we may see on CSI shows. In the end, document examiners should never push their opinion beyond what's merited by the evidence. Instead, experts should explain thoroughly the reasons for any qualification and the importance of limitations in the work. Section 3.3 discusses opinion scales, which are a huge topic all on their own. This part of the report presents various alternatives that are in use and the issues that arise with them, particularly in the context of testing or error rate determination, but beyond that as well. The overall recommendations, both here and in general in the review, are aligned with the logical approach to evidence evaluation, and some of the recommendations we'll see in a bit derive directly from that view of things. Now, Chapter 3.4, subsection 3.4, directly addresses the forensic report, and this is really the meat of today's discussion. Some parts of this will be quite familiar and not at all controversial. Others are be a little less familiar and could be quite a bit controversial. Now, when it comes to the report content, there are many different rules and directives that are out there, things like the federal rules in the United States or procedural rules in Canada and other countries. The discussion in this section is quite extensive, and it forms the basis for the recommendations that follow from it. So let's get right into those recommendations. This recommendation should be pretty non-controversial for most people. It was aimed at those instances when, for various reasons, a report was not provided, and there are several reasons why this might be the case, and all of those various reasons are discussed in this section of the review. But for example, the particular legal framework or status of the examiner in the case may influence whether or not a report gets written. Hence, exceptions are expressly recognized in the recommendation. both for the writing of a report or the content and structure of the report. But there should always be a reason, one that's documented, ideally in the report, but at least in the case file or work notes. Lab policy is one such factor, but contrary to popular belief, policy really needs some basis in reality and cannot be something done to simply avoid doing the right thing or to make things easier. This particular recommendation points to the next one to provide details about report content, so let's take a look at that. Now we come, in my opinion, to the key recommendation in this chapter, and an important one in the overall review, since it addresses the actual content of an ideal and complete report. We must remember that a report provides a record of the parameters, the methods, the examinations, the limitations, and the conclusions regarding the evidence. So it serves a number of different purposes, but the main one is to communicate to the client, ultimately the trier of fact, what exactly is going on. Now, very often a report will be instrumental and even key in pretrial negotiations, and it might serve as a standalone document during court proceedings without any testimony by the FDE. So we have to take great care and make sure that everything that needs to be in there is actually in there. Now, as this slide indicates, there are 17 different elements that should be included in a written report. And a report that you write might be structured with 17 discrete sections, or they may be combined in some manner. I personally find it easiest to title the sections accordingly, but even that isn't really required. You can use free-form text flow. It doesn't really matter so long as everything's in there. But it can be a little bit harder to make sure that everything is in there if you don't split them out easily. A few of these elements are completely expected and normal, things like the demographics, where you describe the submitter and the examiner and where they're located and so on, or the inventory of items. All of these usually are in a report. So I'm not going to discuss those points at all, just in the interest of time. As we go through the different 17 elements, and be fewer than that, remember the starting point. A lab report must be understandable and have a logical flow for its conclusions to have meaning. It should account for all the data, both pro and con in terms of the main proposition and for all alternative propositions, and any sources of uncertainty should be addressed. Now, the first point we'll have is it must include the request for examination, basically what examinations were requested. Please note that this is not the set of propositions used for evaluation purposes. Those are separate from the request in almost every situation. And propositions are generally not provided. We'll talk about them in a minute on another slide. This is more so what was actually asked of us. Generally, the letter of instruction or the examination request will dictate the question asked. And basically what we're talking about is the report has to include details of what was requested, in the manner and the form in which it was requested, because often these can be presented in a somewhat biased or biasing manner. It's required for clarity, because what was requested may differ from what was actually done. Case-related background information can come to us in many different ways. Often it's part of the letter of instruction or the case submission form, but it can also be in an email or a phone call or direct communication with a client. Now, this type of background information or framework information can sometimes be a lot of different information. In some labs, you might have a context management system that applies at the point of receipt, which may involve masking or information control, but that isn't always feasible, especially for private examiners. Now, it's important to realize that proper interpretation of the scientific findings has to occur within a framework of circumstances. The evaluation of those findings must be conditioned on the propositions and on task-relevant non-scientific case information, the framework. Case information is necessary both to set appropriate and relevant propositions and to help to define the appropriate population under the alternative proposition. It may provide pertinent, relevant information that you absolutely must have for a complete evaluation. So simply masking or hiding information is not the appropriate way to approach this. At the same time, any background information we might get is necessarily provisional in nature, so it's important that we indicate that should the framework of information change, then the Document examiner must reevaluate the findings and adjust the opinion accordingly. All of this needs to be presented in the report so that it is clear as to what was given to you, what you were exposed to, what you did with it, how it was handled, if there was vetting, if there was any masking or sequential unmasking. All of this should be outlined in the report so that it's well understood what was done and how. Now, the next element in the report are the propositions which are needed in a proper evaluation process. As noted earlier, the request is usually a question of some type, which must be converted using applicable and relevant framework information into a set of propositions. Propositions are statements, not questions, which ideally reflect the position of the parties. Hence, they are competing and mutually exclusive pairs of statements. The review document notes the report should reflect the propositions used in the evaluation of the evidence and the information that was used to produce them. In addition, the report should indicate that if those propositions change, the opinion of the examiner may also change. Now, the examiner's goal when doing the actual evaluation, which occurs well before the writing of the report, is not to evaluate the probability of the propositions. Instead, it is to evaluate the probability of the findings given the propositions and the framework. This must be reflected in the report. Two key aspects indicated in the recommendation are that the opinion is conditioned by the propositions and the framework, and those conditions may change, meaning that the opinion may change. The latter must be expressly noted in the report. The next point addresses assumptions. Now, some examiners believe, in error, that no assumptions are ever made when doing our work. However, assumptions are, in reality, often made by examiners. They always have been. They relate to the framework information or the nature of the submitted materials. For example, when an examiner uses reference samples to inform his or her assessment, which is in any comparison process, they often make implicit or explicit assumptions about the source of that material, or the adequacy and representativeness of the samples. An examiner might make a determination that a sample of writing is natural, representative of a writer's habits, or adequate for comparison purposes. These are all ultimately assumptions about the material. Now, it's important to note that these are neither uninformed nor naive decisions being made. Rather, they are all tested assumptions, that is, done in the course of the examination. However, any such testing cannot be definitive, with the result being a form of an assumption upon which, in part, the opinion rests. Such assumptions have always been made, but were generally considered to be implicit to the process and rarely expressed or stated outright. Another less obvious assumption relates to the applicability of examiner knowledge to the question at hand. Some examiners assume their knowledge base is appropriate and adequate for all manner of casework, when in reality it's actually best suited to writings with which they are most familiar. Basically, they don't give much thought to whether or not they have the requisite skill and knowledge for the question being posed. Other assumptions may include a decision that an accurate photocopy or image of the writing has been provided, or that the date of a writing is as is purported. Now, it can be difficult to identify some types of assumptions. However, when they have been made, such assumptions should be declared so that the recipient of the report understands the limits of the opinion. In addition, this point, like many others, requires acknowledgement of the uncertainty that exists and how a change might affect the opinion. This can be addressed through a disclaimer like the one shown on this slide. Methods should be outlined, and here there's more than what might first appear. Document examiners apply various methods, and each has its own issues or limits, applicability, and so on. We should be providing details, particularly if, with respect to the opinion scale used. There is far more inter-lab and inter-examiner variation in what scales are used than one would expect when it comes to opinion scales. Now, error rates could be discussed here because error rates do apply to methods as they exist, but there's another section for that later on, so we'll talk about that later. And please note that this particular directive is not about the specific way that a method was applied in a given case. Rather, it's the general method that would be applied and general elements that relate to that method. The procedural aspect, the next point in the recommendations, is the specific detailed aspect for a given case examination. So what were the procedures that followed, and in particular, do they deviate from established methods which were outlined earlier? If they do not, that's fine. You simply say that we followed it. But if there are any deviations, and generally there are some in almost any case, you would note those deviations. It's really aimed at addressing, or at least disclosing, conformity or deviation from the methods that were outlined earlier. And it is specific to the case at hand. Basically answering the question, what did you actually do in the case at hand? If there's no deviation, then there's not a whole lot to say in this section. Now, when we get to the observations, which are often also called the findings, we're really talking about a description of what was observed in a case. The amount of detail will depend on the case and what you have to deal with, but a complete list should be provided. And noting, of course, that similarities and differences or deviations are equally important in comparative types of examinations. This is generally done before the evaluation, which we'll talk about in the next section, which really should be the case in the actual exam process. But in reality, the two listing of observations and the evaluation of those observations might be combined. And in fact could be combined with the opinion that results from that. It really depends on how you approach your work and how you want to describe it. But now we're looking at the specific findings of the case at hand. In comparative or evaluative work, we're really looking at the similarities and differences between the two sets of material, as well as not accounted for elements. Sometimes you have features or components that are in one sample, but they're not present in the other sample, therefore they can't be evaluated at all. So we have to note those as well. When it comes to a more technical report, where you're just really describing the findings, you're just listing the features of note, and you don't have to do the following steps in terms of evaluation. Now, in the evaluation component, in my reports at least, these tend to be the more detailed and lengthy aspect of the work, but it can be very straightforward. Remembering, of course, that we are evaluating the probability of the findings, E in this little equation, given the various propositions and the information or framework that was provided. And we do this for each of the propositions of interest. This is closely related to the previous section, obviously, where we look at findings, but now we are talking about the evaluation of those findings. And it's very important to keep the two things separate. Observations versus, on this slide, evaluation of those observations. And really, it's this area where our expertise comes into play in most instances. Now again, for a technical report where you're simply providing the findings themselves, there may be little or nothing here because there's no formal evaluation done. And here we come to the conclusion or the opinion, which essentially is a statement that is reached based on the observations and the evaluation of those observations. And some of you are probably thinking at this point that we have an awful lot of different sections in here, and that's very true. We have the method and the procedures and the observations, the evaluation of those observations, and finally we get to this point where we have a conclusion that's reached based on that. Now there is clearly a connection between them and a flow that follows through in the reasoning process. Now, sometimes these different sections can be combined in some manner, but it's important to do that in a clear way if you do so. Keeping them separate ensures understanding about how all the different things are done and how they all come to play in our work. When it comes to the opinion or the conclusion, when an association is made, when one particular proposition is favored over the other, the significance of that association should be communicated clearly so that the qualifications that apply are noted and understood by the recipient as much as possible. For evaluative type reports, this is the ultimate information that we're trying to get across. For a technical report, there may be very little that goes in this particular section. All opinions, as with much of the information that goes into those opinions, we need a disclaimer that notes that should things change, the opinion may change. So a standard disclaimer that I generally use goes along the lines of this. It's important to note that opinions expressed in this report are based on task-relevant background information. That's one conditioning factor. The exhibit materials provided, that's another factor, as well as specific propositions utilized in the evaluation. I generally say, and as reported. Should any of the information, exhibit materials, or propositions change, you could also add assumptions in here. The opinion may also change. And in particular, if different propositions are of interest, the document examiner should be contacted to discuss the matter further. I generally like the last line because propositions are the aspect or the element that should relate to the position of the parties, hence they have particular significance in the overall process. Now, you don't have to do things the way this disclaimer is done, but I find that it works very well. Limitations are a statement of things that don't let the examination or the procedure or the evaluation be conducted fully. I generally, personally, list these early on in my reports, sometimes even in the observation section or just after it. And then I discuss the effects of those limitations in the evaluation section leading to the opinion. But it has to be done somewhere. And there are many, many things that can affect the evaluation of the final opinion. Limitations, whatever they may be, whether it's reproduction quality, the amount of material, the comparability of the material, and on, these should be listed and discussed as appropriate. Error rates need to be discussed as well. The statement of potential error, and if available, provide those rates. If none is known, then that fact should be disclosed. Now, of course, we know error rates are very hard to determine. There's lots of variables. Do we try to have a global error rate, an individual error rate, or method, et cetera, et cetera? We can't really do this effectively, which means that for our discipline, we do not necessarily have very good error rates to provide. We can, of course, discuss procedures we use, quality assurance procedures, to mitigate potential issues of error. But this point is tell people what it is that we have for error rates, if we have them. And if we don't, we need to acknowledge that we don't. And I would say that for the most part, that's the reality of it. Now we come to the review of the conclusions, what some might call a peer review or a technical review, generally done as a quality assurance step. The requirement is that we should be describing what was done and how it was done. And if a disagreement occurs between the document examiner and the reviewer, what the outcome might have been. There are two examples given here, one for when a review is not done, and one for when a review was done. But you'll note that in the latter, no particular outcome is mentioned. Now, the details regarding the outcome should be documented, particularly if any change in opinion has occurred due to the process. But whether that occurs in the report itself or in work notes may depend upon the lab procedures, policies, or jurisdictional differences. But in any event, these are two examples of what you might use when you do such a review. Now, the report does provide an example laboratory report, and although it's quite rudimentary, each part of the example report is marked to indicate which of the 17 elements is addressed by that part of the report. So, for example, you have the beginning of the report, which has some of the demographic information, who's the examiner, the lab, who submitted it, the case identifier, and so on, inventory of evidence, each of the sections, the examination that was requested, which may have a lot of detail or may be very simple, the propositions that were used. This is a statement of what propositions were actually utilized, procedures. In this case, this simple paragraph covers both method and procedures. Personally, I think it might require a bit more information than we have here, but that's fine. A statement about error rates, and et cetera, et cetera. So I'm not going to go through these in any detail, but I recommend that you get the report and read through it. The remaining sections and recommendations clarify and reinforce some of the elements already discussed, but the focus now shifts towards testimony by the examiner. Remember, testimony often does not happen even though the report itself ends up being used. Nonetheless, there are many elements of testimony that need to be discussed. The initial discussion relates to impartial testimony and the reporting of the possibility of error. Those result in the following three recommendations. First, recommendation 3.3. Now, this should seem completely obvious, but there have been instances where this particular thing was not done, and the forensic document examiner who did the exam did not actually testify. Clearly, the subjective and personal nature of our work requires this, with very few exceptions, and those exceptions are discussed in the report. But the testifying expert's personal knowledge of the examination and of the contents of the report that they've written is critical for proper education of the fact finder. Recommendation 3 and 4. Again, this seems pretty obvious and is covered in a lot of directives and codes of ethics. The requirement that document examiners be impartial, both as a general matter and in terms of testimony, is appropriately very widespread. You can find it in various guidelines and professional responsibility codes and codes of ethics and so on. One thing that is important to remember is cross-examination in the course of testimony and the search for truth, so to speak, is an important element of any litigation involving forensic evidence. The examiner must remember they serve the court or the trier and not one party, even if they're called by one side. One facet in this recommendation relates to the examiner's duty to correct, which continues after the trial. Now, it may seem unlikely, but since every opinion is conditional, should any of the information change after the fact in a way that it affects the opinion, the examiner has a responsibility to make an effort to inform the trier of this change. This relates literally to the duty to correct, which is discussed more fully in this report in Chapter 4 on QA and QC. The next recommendation relates to error rates, and given the lack of meaningful error rates thus far, examiners should at a minimum be prepared to discuss and explain the relevant quality assurance steps that are taken, such as they may be, to reduce the potential for error. At the same time, the report also notes that although the use of a robust QA system should reduce the magnitude or frequency of errors, it's an examiner's duty to acknowledge in both written reports and oral testimony that the possibility of error always exists, hence the last sentence in this recommendation. The report also states that to the extent that the error rate or significance of uncertainty is unknown, those facts or elements should also be reported to the fact finder in both reporting and testimony. In other words, if we do not have error rates, this fact should be disclosed. Now, when we consider examiner knowledge in general, the working group noted instances where things did not go particularly well during testimony for individual examiners who found themselves essentially defending the discipline during admissibility hearings of one sort or another. They noted forensic document examiners individually have the responsibility to support the admissibility of handwriting examination when answering questions from an attorney or judge. Knowledge of underlying principles and research enables the expert to answer questions relating to admissibility issues. And those issues usually arise in terms of the accuracy and reliability of the methods being used, which in turn gets into the testing of those methods and the results of that testing. This section of the review discusses why any and every examiner needs to be prepared to defend the discipline in terms of admissibility. Rules pertaining to this will vary, of course, but all examiners should be capable of defending the discipline if or when they are challenged. To that end, the recommendation 3.6 details some of the things that every examiner should know. When it comes to relevant research, a working or functional knowledge would include the ability to describe things like the sample size of the reference studies, the composition, the study test conditions, and of course the specific findings of any given study. Now, there are quite a few studies that do give us some insight into these types of things. The CAM studies, those done by Dr. Found and others at La Trobe, these are all relevant studies, so you should know details of those. The report also reiterated that in court, the lab report is the foundation of testimony, whether it be an evaluative or technical type of report. And fairly obviously, the examiner must be able to decipher, clarify, explain, and defend the report contents. That's pretty obvious. But further, the examiner must possess, one, a working knowledge of the discipline, all facets, must be able to explain the foundational principles of handwriting analysis, generally going beyond the class and individual paradigm and getting into things such as complexity in writing and in signatures. But these all generally deal with the validity and or reliability of the things that we do and all the relevant studies supporting those concepts. And of course, be familiar with any studies that do indicate a potential or known error rate. Lastly, demonstrative aids, visual aids, be these charts or images, can be extremely useful and helpful when explaining the basis for an opinion. But proper understanding of the evidence in general requires an accurate representation that's both balanced and fair. The goals or purposes for such charts and images are essentially to help the viewer, often the judge or juror, to see the features of interest and to better understand those features in some respect, or finally to fully appreciate more subtle elements in the features that would otherwise be obscured. So these might be something that is literally covered with an obliteration that we bring to light, or it might be some chart that demonstrates a particular variation in handwriting samples and how they are similar or divergent. In that respect, demonstrative aids can be, of course, double-edged swords. A good visual aid can assist the viewer in understanding what the examiner is saying, but a poorly prepared aid might confuse the viewer or, perhaps worse, provide a biased perspective, simply, for example, by taking the information out of its original context. Now, it's important to note two key facets that the visual aids that you use and prepare must match your report content, which itself is supposed to be balanced and fair. And it must match any of your anticipated verbal or oral testimony. So when you're preparing charts and images, it's important to be proactive and include images of features that could raise questions about the opinion. That gives an opportunity to explain why the opinion was reached, taking all of the features into account. A fair and balanced presentation is always best, even though it may mean a bit more work explaining why a given opinion comes out of what is seen. It can be tempting to skew the presentation to try and make a point or make things easier, but doing so is actually a form of bias and a potential distortion of the evidence. Hence, this recommendation says they must accurately represent the evidence, both in terms of similarities and divergencies. The report of the Expert Working Group on Human Factors and Handwriting Examination is freely available on the NIST website in their publication database. You can get it from the URL shown on this slide. Now this is revision 1, which was published in 2021, and it's the one that you really want to get. I hope that my brief review of Chapter 3 has piqued your interest in the report. There's much, much more in it. So I hope you'll take the time to read through it and consider how it might apply to your own lab or to your own work. Now, if you have questions about this talk or the Human Factors report for that matter, please feel free to contact me at the email shown or via the HUVA event website. I look forward to chatting with you. Bye for now.